Good afternoon and welcome to this webinar, which is being brought to you by Town Legal and Landmark Chambers. So today's session is all about the recent amendments to the use classes order and specifically the introduction of the new Class E. I think it's safe to say that these recent amendments are probably the most fundamental that I've seen in my planning career to date. And I've been knocking around for quite a long time already. I am joined by a brilliant and learned panel, of course, to help us negotiate the issues, but I don't know why you're laughing, Simon, already, raised by the new Class E. So without further ado, let me introduce them to you. They will say hello as I go around them. Actually, when I was preparing for today, I realised that as a result of lockdown, I could now actually introduce every one of us on this panel by reference to a blog or a webcast or a podcast, because that's what we're all doing in lockdown. So starting with Simon Ricketts, because he's at the top of my screen, my fellow partner at Town Legal, author of the famous Simonicity blog, although Simon was obviously on it well before lockdown because his blog's been going for a while. Simon, say hello.
You're pronouncing it right. Thank you, Simon.
I did, yeah. We also have Duncan Field, another of my brilliant partners, producer of the Town Legal at Home video series and star of numerous webinars. Say hello, Duncan.
Hello, Duncan.
Okay, I can see how this is going to go. Moving on to our learned barrister types, we have the excellent Heather Sargent, author and star of the Planning Tea Break. Hi, Heather.
Hi, Meeta.
And last but far from least, Zack Simons, with half his beard back, our favourite Planner Act blogger and star of many other podcasts too numerous to mention. Zack.
Hello, Meeta. Good evening, everybody.
And I'm your chair, Meeta Kaur. I'm also a partner at Town Legal, and I can be found on our podcast, The Planning Brief, sometimes with Zack and Heather, and my other brilliant partner, Louise Samuels, who's not on the panel today. So to begin with, a few housekeeping points to note. Your microphones are automatically muted. You don't need to adjust your local settings. We very much welcome questions, so please do submit them in the Q&A section, which will be at the bottom or the top of your screen somewhere. We have been inundated with questions, I should probably say, so we'll try to answer as many as we possibly can during the event. What we've done actually is to try and make sure that the topics that we go through hit as many of those questions in advance, but I apologise if we don't hit everything. However, the webinar is going to be recorded and you'll get a link to the recording shortly after the event finishes. If you lose your connection at any point, then please do just rejoin by clicking the same link. So without wasting any more time, as we've only got an hour, let's start by reminding ourselves of what this session is about. On the 20th of July, the government made the Town and Country Planning Use Classes Amendment England Regulations 2020. They come into force on the 1st of September, and they shake up our old friend, the Use Classes Order, in some pretty fundamental ways. They create a new Class E, that's what we're going to be focusing on. What is Class E? I'm just going to run through it very, very quickly. So we had it in front of us. It's use or part use, and that bit's noteworthy. 4, the display or retail sale of goods other than hot food. So previously that was in A1. The sale of food and drink for consumption on the premises, previously A3. Provision of financial, professional or any other services which it is appropriate to provide in a commercial, business or service locality, and I'd be interested to hear what people think that might be. That was previously A2, more or less, and I do mean more or less. Indoor sport, recreational fitness, previously D2, and then we've got medical health services, creches, day nurseries or day centres, or previously D1. Clearly there are many other changes. It's not possible to divorce those entirely, but we are going to try and focus on Class E. So let's turn to our first question and our first issue. And that really is how is this all going to work, particularly when we talk about the transitional arrangements that there are in the regs. So Duncan, just a couple of easy things to cover there, including our favourite regulation, Regulation 7. What's that for, actually?
That's a good question. I'm not sure I'll be able to answer that, but I can offer some disparaging remarks. To start then with some basic principles, obviously all the uses that Meeta read out within Class E are all together in the same use class, which means they're taken out of development control as a general rule, because changes within the use class do not constitute development and therefore don't need planning permission. That's subject to site-specific considerations, which we'll come on to. The other point with the operation of the use class is that there has to be an actual lawful use before you can make use of that change. Not necessarily an active use, but an actual lawful one. And we know from the regulations as well that this change will apply anywhere in England, not just the high street, which was probably the focus for government's attention in trying to revitalise market town high streets and so on, which have increased in vacancies and not really thriving, but actually out of town, in locations like retail parks, business parks and so on. So potentially very wide ramifications. And I think it's also important to note that point that Meeta made as well, that Class C refers to part use, which appears to be encouraging co-location of uses all within Class E. So as Meeta said, this will come into effect on the 1st of September, and there are various transitional provisions which have raised quite a lot of questions. So I'll try and touch on them briefly. First thing is permitted development. For a period of time from the 1st of September through to 31st of July next year, permitted development rights remain unchanged. And effectively, if you're in the permitted development world, you have to assume that the use classes order is as it is now, or as it exists on the 31st of August. So that means that permitted development rights, for example, changes from hot food takeaways to shops, financial professional services, restaurants, cafes, offices or residential, those rights will still exist at least until the 31st of July. Likewise, changing from a shop or bank to leisure use within what used to be, or what is currently known as D2, also stays for at least until the end of July. There's similar provisions for reading in the old use classes vocabulary into applications for prior approval under the GPDO, not surprisingly, and also Article 4 directions. And Article 4 directions that are made before the 1st of September should be read in the same way as they are now. Pausing there, I think it's important to remember that Article 4 directions only control permitted development rights. So this Article 4, despite the transitional provisions making reference to the current use classes order, Article 4 is not going to be a means by which local authority can control the new use class E. And finally, we come to the exemplary parliamentary drafting that Meeta referred to in Article 7 of the Use Classes Amendment Order, which lists A1, A2, A3 and B1 as uses which, if in use on 31st of August, will be treated as Class E after the 1st of September. And that, of course, omits a number of uses which are going to be in Class E. It also includes a use which isn't going to be in Class C, namely small community shops. So I think Article 7 has caused more confusion than value, shall we say? To my mind, Article 7 is attempting just to be, a declaration of some of the consequences of the amendments that are introduced to the use classes order for the avoidance of doubt. But actually, instead of avoiding doubt, it's created doubt. But my view is that Article 7 can be more or less ignored, to be honest, in terms of the legal effect of the changes to the use classes order.
Thanks, Duncan. I think you're right, actually, about the confusion, in particular around about the distinction between PD rights, which allow changes of use between classes, and changing use within a class, which the use classes order obviously says just isn't development at all. And I do think that perhaps in part it's come from Class E and just how broad it is. I think it's quite difficult for us all that have been working with youth classes order as it is to kind of get our heads around actually that this is all lumped together. I don't know what other panelists' views are on that.
I couldn't agree more, Meeta. I think that it's so interesting. A lot of the questions that we've had in advance of this session from all of you talk about Article 4 directions, and we're asked repeatedly, how could they be used in order to sort of constrain some of the wider ramifications of Class E? I think to get to the bottom of why Class E actually is, word of the week, a bit radical. It's worth just spending 30 seconds reminding yourself what the use classes order actually does. And I said some of this stuff in my Planner Acts post the other day about Class E, but do have a read there. But in a nutshell, and it picks up on what Duncan just said, Town and Country Planning Act 1990, Section 55(1) defines development. And as we all know, operational development or changes of use is what we find there. Section 55(2) gives us a carve-out list of things which would have been caught by 55(1), but that the Act deems not to be development. And one of the carved out things there that we find is a change of use within the same class. As Duncan's just said, that kind of change is deemed not to be development. And see Section 57, if it ain't development, you don't need planning permission. Now, all of that, of course, might sound completely obvious to lots of you, but it's worth remembering that because Class E is very much not a permitted development right. Local or planning authorities cannot exclude its operation through an Article 4 direction. The point goes a lot more fundamental than that, because as Duncan's just said, the changes of use we're talking about under Class E do no longer constitute development at all, carved out. And if it ain't development, then subject to conditions, which Simon will come to later on, it's taken outside the scope of development control. You don't need permitted development right because it isn't development.
Brilliant. Brilliant and succinct explanation. Planning 101 plus second shameless plug for your Planner Act blog, but okay.
Absolutely. Can't do enough plugs.
We should probably move on at that point, actually. Simon, I want to turn to you now on another issue that we've all been discussing endlessly because we're fun like that, which is conditions. What now for conditions? Clearly, the issue of existing conditions, we all know that there are plenty of planning permissions out there that have conditions on them, restricting use within a class, between classes, and there's plenty of case law that's actually examined that issue and the form that those conditions should take in order to be effective. But how are we going to operate this going forward in terms of the existing conditions with the old use classes on, and what do we anticipate for this type of condition going forward in the new use classes order world?
Yeah, sure. So, yes, the focus is absolutely now, in my view, going to be on conditions, both existing conditions on permissions and authorities' ability to control future development by imposing conditions. So it's worth just running as precisely as possible through what the legal position is. Number one, in principle, a condition on an existing planning permission can operate so as to disapply the operation of the use classes order in total or in part. Whether or not the specific wording of a condition achieves that comes down to its interpretation in the light of case law. This isn't a new issue for planning lawyers. It's exactly the same issue that we've had for many years in relation to, for example, A1 planning permissions that excluded often the sale of food or contained other restrictions on the sale of goods. Similarly, restrictions as to, the property can only be used within B1A or can only be used for B1B and C. Next, the court's approach to interpretation of planning conditions has undoubtedly changed in recent years. The turning point was probably the Supreme Court in the Trump case. Our friend Mr. Trump was objecting to an offshore wind farm off the coastline from his Scottish Gulf resort. One of the issues was about a condition on the consent that required a design statement to be submitted, but the condition didn't specifically go on to require that the development be constructed in accordance with the approved design statement. And one of the main issues was, well, can you imply that into the condition, or did you need to take a more traditional, very restrictive approach to the interpretive conditions and implying words in that weren't there? And Lord Hodge sets out in a paragraph a statement which the courts have then come back again and again. You look at picking out the key bits, you look at what the reasonable reader would understand words to mean, reading the condition in the context of other conditions and the consent as a whole. You look at the natural and ordinary meaning of the relevant words, overall purpose of the consent, other conditions which cast light on the purpose of the words, etc. And you can look at other documents that are connected to the application for the consent, depending on the circumstances. And then the other key case, again, Supreme Court. We planning lawyers honoured when one of our, you know, that we have a planning case in the Supreme Court. We've got two on conditions. The other, the London Borough of Lambeth and Secretary of State last year, where Lord Carnworth, you know, sort of summarised that approach, and there, you know, the case concerned a condition which restricted the operation of the use classes order, but there it was about really whether a Section 73 permission that sought to amend the restriction but didn't reimpose it as a condition should be read as reimposing it as a condition, and the court said yes. So I'm drawing that out because that's very different from 5 or 6 years ago. We were looking at very old cases like carpet decor in the 80s, Dunoon in the 90s, where the courts were really throwing out claims by local authorities that conditions should be interpreted so as to cut back on the operation of use classes order and GPDO. So now we really need to look at the particular wording of the condition and the circumstances and take a common sense approach. So that's existing conditions. And then very briefly, in terms of whether authorities can impose conditions now moving forward on permissions so as to cut back on the operation of Class E. Well, one, legally, in principle, yes, they can. Number two, whether they're justified in planning terms comes down to issues which Heather and Zack are going to discuss about the operation of local plan policies and the NPPF. But I'd just point out that at the moment there is some indication in the government's planning practice guidance that conditions that restrict the future use of permitted development rights or changes of use might not pass the test of reasonableness on necessity. The scope of such conditions needs to be precisely defined. So there is a pointer in the PPG that you know, warns authorities against a sort of blanket approach to excluding these things. But you know, it's all down to the particular circumstances. I think I'll stop there.
Worth noting, of course, that the PPG has not been touched yet since the Class E amendment to the use classes order has been introduced. Absolutely. So we await up to date guidance if any is coming from MHCLG. If any of you are on the line today.
Could I make one final? I forgot to say the restriction could, of course, be by way of Section 106 restriction as an alternative as well, which is another kettle of fish.
So, I mean, just, Simon, very briefly then, because I think this is, again, I think it's the simplest things which are really causing problems, understandably. You have a permission with a condition on it that is restricting the use of the development to a particular use and excluding the operation of the use classes order. And perhaps it references one of the old use classes in it. In terms of what we know about how you should interpret planning permissions, it's pretty easy for us to understand what that means. We know what the condition is saying and what it's referring to, and that doesn't change simply because of the use classes order changes that we've just seen.
Yes, that's right. So when I'm looking at a condition to see if it excludes now the opportunities that might arise for landowners with Class E, I'm looking to see whether the wording of the condition unambiguously excludes the operation of the use classes order, and simply because use is described by reference to the current order doesn't necessarily mean that it excludes the operation of Class E. But you You know, it all comes down to really seeing the exact words, and I never fail to be surprised at how many permutations of words there are for these sorts of conditions, and how many times we all see it all slightly mangled.
Yeah, and find ourselves, yeah, looking at conditions that don't differ very much, but actually we can still spend hours scratching our heads over them.
Yes.
I think at this point it's probably worth moving on to you, Heather, because you are going to talk about another big area that is going to be fertile with issues, namely local plans.
Yeah, thanks, Meeta. I think fertile with issues is actually a very positive way of putting it. The thing that's particularly struck me is that, as we'll come on to discuss, the new amendments raise some really fundamental questions, such as, are development plan policies now out of date if they predate these amendments? And in the absence of any guidance so far from MHCLG, as Zack said, there's no new PPG yet to accompany the changes. If there is a dispute, it'll be for planning inspectors, first of all, to work out the answers, and then potentially the courts. And the degree of uncertainty around such fundamental questions that will exist until answers are forthcoming from appeal decisions or court decisions seems to me to be not ideal. So, not to do myself out of a job advising on all of this, but I, for one, would welcome some guidance from MHCLG, I think. The other aspect of this that's unclear to me and that's particularly relevant to local plans is what the intent behind the changes actually is. Are they really aimed at existing development to help with the anticipated impact of the pandemic? The impact assessment for the amendments says that it's an interim measure because the legislation's been brought forward at pace to support economic renewal, and the explanatory memo also refers to the pandemic. Or are the amendments more ambitious? Are they also aimed at future development? Are they aimed at moving the entire system away from thinking in terms of A1, B1, so on and so forth, away from thinking in terms of retail as distinct from office use, and towards thinking in terms of a global Class E use? I have to say, if the changes are supposed to bring about a more fundamental shift in relation to future development, then there's more work to be done, because existing policy, be that local planning authority development plans or the NPPF, isn't properly set up to receive these changes at the moment. There are 2 points in particular that I want to just touch on in relation to local plans. First of all, the query about whether the new legislation means that existing local plan policies are likely to be found to be out of date, specifically for the purposes of the NPPF and paragraph 11 and the application of the tilted balance. And then in practical terms, what does the new legislation mean for local planning authorities who are currently preparing local plans? So on the question of whether or not existing policies out of date or will be out of date once the amendments come in, if we take as an example a site that's allocated in the local plan for B1 use only, and an application's made either for just broad Class E use or, for example, for use as a restaurant, which at the moment is Class A3, and the local planning authority says no because it doesn't accord with the development plan that contemplates that the site will be brought forward for B1 use, then the applicant argues, well, the policy that restricts the site to B1 use is out of date following the amendment, because the amendment provides for flexibility between B1 and the A-class uses. It seems to me it's not impossible that an inspector might accept an argument that the policy is out of date following the amendments, but I think there are 2 arguments that the local planning authority could make in support of the policy remaining up to date. First of all, it could have a go at saying that whether or not a policy is up to date or out of date is largely to be assessed by considering whether it's consistent with the NPPF. And since the NPPF hasn't been amended, or not yet, then the policy remains consistent with the NPPF, and so it's still up to date. I think potentially the more compelling argument is that the local planning authority can say, well, hang on, it's true that existing development has the benefit of Class E, so we can't stop an existing office from being turned into a restaurant, as Duncan and Simon have explained. But that doesn't mean that we should be prevented from conditioning future grants of planning permission so that the Class E flexibility is actually removed or restricted. And so in other words, if we're allowed to condition a grant of planning permission to say, okay, you can have an office here, but we're removing your Class E rights, so you won't automatically be able to turn it into a restaurant, then there's no reason why one of our policies should be out of date simply by virtue of it being less flexible and less generous to an applicant than Class E is on the face of things. And really, I think that goes back to my preliminary point. Are these amendments focused on existing development, in which case it doesn't much matter if local planning authorities are able to condition future grants of planning permission so as to restrain the operation of Class E? Or is the intention behind the order actually to remove the local planning authority's power to restrain changes of uses between the A classes and B1? If that's the intention, then I think really it does need to be made clearer to local planning authorities what they can and can't permissibly achieve through imposing conditions, or indeed through a section 106, as Simon mentioned, because at the moment, beyond the pointer in the PPG that Simon referred to, there's nothing that suggests that local planning authorities can't impose a condition that in effect restrains the operation of Class E, and the PPG hasn't yet been updated following publication of the amendments. My view on future development is that it's seriously questionable whether we should move to a system where the local planning authority has no control over the changes between the E-class uses. Otherwise, I don't see how we can ensure, subject to a caveat I'll come back to, but I don't see how we can avoid necessarily ending up with, for example, too many offices and not enough retail floor space. Which brings me to the second point, is what might all this mean for local plans that are currently being prepared? The difficulty, of course, is that assessment work will have been carried out with the current use classes in mind. So how much retail do we need? What quantum of office space do we need? Where in geographical terms are all of those things going to go, those distinct types of development? And one might assume from the amendments that in future local planning authorities should instead simply be asking, you know, how much Class E space, in inverted commas, do we need and where's it going to go? That approach, as Zack will explain, is problematic in terms of the NPPF as it's currently drafted. I also think it's likely to be impractical, because even if you work out how much retail you need and how much office space you need, and then you add them together and you just allocate that quantum as Class E development, how in due course, again, do you ensure that you don't end up ultimately getting all of it coming forward as retail or all of it going as office space? So for that reason, independently of the NPPF, I think local planning authorities are going to have to make clear in their policies that they'll exercise some control over the mix of uses that actually comes forward under Class E. Either that could be done by restricting the flexibility from the outset, so by allocating a site, for example, for retail, and making it clear in the policy that conditions will be imposed on grants of planning permission to prevent switching to the other Class E uses. Or I haven't particularly thought through the detail of this, so don't ask me how I would actually put this in planning policy, but I suppose a slightly more relaxed approach would be to say, we're allocating this for Class E, we'll discuss the precise use or the mix of uses with you as and when you start bringing the site forward, depending on what's happened by that point with the other Class E allocations. I suppose the other perspective to all of that is that we should accept that the local planning authority doesn't have any control over the precise mix of uses that comes forward under Class E, and we just leave that for the market to control and to influence. But that would, I think, certainly be a shift away from a truly plan-led system, although it could be that that is the direction that this government wants us to go in.
Thanks, Heather. That was brilliant. I think, you know, at the beginning there, you probably highlighted something that we've been talking about more generally, which is, you know, where the opportunities lie, and you know, and what I'm talking about here is a distinction between development that is already permitted and implemented versus opportunities for development that will come forward after these changes have sort of worked their way into the system properly. And I think there is definitely a distinction between those two at the moment, definitely, and particularly before we have further guidance and, you know, see how these things sort of work their way through into the GPDO, etc. Out of interest, Heather, Zack, are you advising any local authorities on local plans that they currently have in the system, i.e. going through the examination process? And if so, what sorts of issues are they encountering with PINs, or just generally what, you know, what's making them scratch their heads about this at the moment?
I think it is particularly the question as well, you know, we've got this planning draft that refers to a B1 use. Basically, what do we do now? Should we instead be referring to Class E? How does, you know, the specifics around how does the wording need to be amended to reflect Class E? To which I think the response is, as I've said, you know, obviously you wouldn't want to be referring to B1, but you can refer to retail, or you can refer to the specific categories within Class E, and you just need to work out what you're going to say in the policy to make your intent clear as to the scope of the Class E use rights that you are actually providing support for.
I couldn't agree. I couldn't agree more. I'm advising a dear old authority who are getting very close to having a positive recommendation from a planning inspector to push their plan over the line after years of work and examination hearings and all the rest of it. And then Class E, and then end of July, a letter from the planning inspector saying, well, hang on, you know, what about this then? Do we need to rewrite all of your allocation policies? And I'm giving them advice on this tomorrow morning. So it's a live issue, and I know a colleague in Chambers is doing it with another local authority who are in a very similar situation. Really careful thought, as Heather has said, it's going to need to be given to the response to the planning inspectorate. To try and persuade, if this is the play that the authority tried to make, to try and explain to the inspector how, notwithstanding these quite fundamental changes in the system, the plan as it's been drafted up until this point can still meet the test of soundness in the MPPF. TBD on that one, Meeta.
And that seems like a very neat segue into a discussion about the MPPF, really.
Yes, the MPPF, that's my one, isn't it? So as I said a few minutes ago, I thought it's worthwhile reminding ourselves of what the use classes order actually amounts to, i.e., as Duncan said, it's a carve out from the definition of development, because lots of the questions that we've had in advance of this evening relate to how policies, permissions, and the conditions attached to those permissions may be transformed under Class E. And you've obviously heard quite a bit about that already. But the point I wanted to stress at the outset is something that Simon picked up on earlier. It's that the use classes order is an important part, but only a part of the framework within which we interpret all of these documents, policies, planning permissions, and the conditions attached. As Simon said, Lambeth in the Supreme Court last year, if it taught us anything, and it might not have taught us very much, but that's a topic for another webinar, it taught us that we need to avoid being too techie about all of this, because in the end, the court's interested in the ordinary meaning of these documents, read in their context in the light of common sense. And as I've said, terms of the use classes order, important, potentially a component of that overall meaning, but they're not the only bit of the context. And they may not even be the most important aid to interpreting, for example, an existing planning permission or a policy. So we shouldn't lose the wood for the trees. All of that said, just a couple of minutes getting fully lost in the trees of the MPPF. Of course, the latest revision of the MPPF is barely a year old. Lots of speculation in the last few months as we went into lockdown on whether it needed revision anyway to help kickstart the economy, to give a greater emphasis to the economic benefits associated with development and the like. But dear me, if we thought it needed amending before, after Class E, I think the case for having another look at the MPPF is overwhelming. And I wanted to give you just a few points where we see the tensions simmer. So one of our three objectives for achieving sustainable development is the economic objective. That requires, we're told, ensuring that sufficient land of the right types is available in the right places. And we're told to meet that objective through making plans. Strategic policies, we're told, have got to make sufficient provision for housing, okay, but also employment, retail, offices, leisure, and other kinds of commercial development. See paragraph 20, see paragraph 85, see paragraph 23. Those policies need a clear strategy to bring land forward to address objectively assessed needs. I know this is all very familiar stuff, but you can obviously see where I'm going on how Class E puts the cat amongst the pigeons, including through site allocation, something that Heather's just talked about. Now, it becomes enormously difficult, putting it diplomatically, to do some of those things if government has deemed that switching between different kinds of employment, retail, or other commercial development should fall outside the scope of development control. The use classes order has been, Heather's touched on, a building block of how plan making authorities have sought up until now to control, plan for and meet the needs of these different sorts of uses. But of course, where the rubber really meets the road, right at the heart of plan making, is the soundness test at paragraph 35 of the framework. For a plan to be positively prepared, it's got to meet objectively assessed needs. What for? Retail, commercial space, office space, etc. But if changing between those uses doesn't comprise development, so could in principle occur without the need for planning permission, how can plan makers derive any confidence at all that needs, once they've been assessed, can be met? And of course, you may be thinking, well, things very regularly do not go according to the best laid plans of local planning authorities through their site allocations. Fair point. But this is a step further, because MHCLG want plans. They want up-to-date plans across the country by 2023 or whenever. They've set criteria in the NPPF to judge whether those plans are acceptable or unacceptable. But they have now, at a stroke, removed one of the basic legal mechanisms through which the provisions of a plan can actually take effect, i.e. development control to manage what are now Class E uses. So it's a tricky situation that planning authorities like my dear old clients find themselves in. I'll drop in one more NPPF point, and it's a substantial one before I pass the baton back to Meeta. The sequential test, because in the end, Class C is supposed to be about revitalising the high street, town centre first policies and all the rest of it. You'll be familiar with the NPPF's definition of main town centre uses. That includes retail, of course, leisure, entertainment, cinemas, bars, pubs, offices, tourism development, all sorts of things. Now, if you're in that category, as you know, and if your site's not in the town centre, you need to meet the sequential test, all of that, see Part 7 of the framework. And you may, of course, also need an impact assessment showing how your scheme impacts on the vitality and viability of the town centre. Now, as you will know, these can be mission critical pieces of work, and if you fail them, then the NPPF says your application should be refused. Well, here's the problem. Class E includes some quote unquote main town centre uses, retail, office space, but it also includes some things which are not defined as main town centre uses, medical services, industrial uses, what we used to call B1C, which leads us to a difficult lacuna. The ability to apply for, say, an out-of-town medical centre to get your permission in the bag, and then with no need for further planning permission, change use to a restaurant or retail, and thereby avoid the operation of the sequential test altogether, all of which highlights the importance of careful and thorough use of planning conditions, which Simon's already touched on. Back to you, Meeta.
Brilliant. Thanks, Zach. That was really excellent. We could obviously spend more time talking about both local plans and the NPPF, but I'm just a bit conscious of time. So moving on, an issue I wanted to touch on was actually the strategy for current applications. What can you do to anticipate and perhaps try and take advantage of the new flexibility, particularly in Class E? And I suppose the short point is, at the risk of sounding like a lawyer, that it depends. I think it depends on a number of factors, and just to touch on, one or two of those, I think the main one is, how close to submission are you actually? You will have carried out assessments if you're very close or pretty close. You'll have carried out assessments, including environmental impact assessment if you have if you're dealing with EIA development, and then that'll have been carried out on a particular basis, on the basis of particular assumptions. And I'm going to come back to you in a minute, Duncan, on EIA actually. So you could hold off for a period, but you also need to be clear, I think, about whether you think you might destabilise the process or indeed your relationship with the local planning authority. And I think another point worth mentioning is that on large scale development, we often see flexible retail and commercial space being applied for, and local planning authorities are completely accepting of that. That's absolutely fine. In London, that's commonplace in particular. So when you start to dissect it a bit more, what you realise is that actually Class C doesn't necessarily always add much or possibly nothing in those sorts of situations, because actually local planning authorities are doing it already. So you just need to, I think there are a number of reasons for why you might want to think carefully about just being a bit too clever about sort of trying to figure out how you can build in some flex now, but really think it through and really think through the sort of cost benefit analysis, I think, at this stage. So I said I wanted to come back to the issue of assessment and EIA generally. Duncan, I know we've been discussing that and how you might need to address EIA going forward. Have you got some thoughts on that?
Yes, thanks, Meeta. I mean, really, I think it's not radically different to the position we're in today when you, for example, would apply for a flexible use permission for a variety of uses. For EIA purposes and indeed for other assessment purposes, you would have to assume parameters for individual types of uses which have differential impacts, and ultimately it would be justifiable for the local planning authority to then condition those parameters, which obviously would reduce Class C flexibility, but would ensure that permission is granted only for that which has been assessed. So I think your point about how much flexibility does Class C add to new planning, existing or future planning applications is a good one, because if the local authority is uncomfortable with that flexibility from an impact point of view, and it's not assessed, then they can impose conditions restricting the use of Class C, particularly if there's a policy justification for doing so. Otherwise, if you get permission for one type of use which has been assessed and they do not impose any further restriction on changes from that use within Class C, then you obviously, once implemented, can change to other uses within Class E. I think perhaps just going back to that other point you made about what do you do about existing applications, with that in mind, I probably wouldn't do much at all, to be honest. I think the government's provision about planning applications continue to be determined as if they refer to the current use classes was probably meant to be helpful, simply because it avoids having to make an amendment to the application to change the description of development. I don't think they intended to create any clever pathways to utilising Class C. I think it's simply that they just tried to minimise the administrative burden of the switch to the new use class.
Yeah, no, I agree, although it's kind of interestingly drafted. Because it says if you put in an application, I think it's during the material period, isn't it, that you you refer to the old classes, then it must be determined in that way. So presumably, if you don't refer to the old use classes,
yes.
Scope for something else to go on. Yeah, that and Regulation 7, we can add those to the use classes order changes soapbox of issues, I think. And then fight over the soapbox. I don't know if, I'm certainly advising on a number of those sorts of issues for current applications, and sort of going around the houses and giving it proper consideration, quite rightly, I think. But I don't know if any of you have anything to add, or you're finding the same sort of things coming up. Oh, Simon, hand up.
Little hand went up. Yeah, but very definitely everyone is focused on Article 4 and what it means when it says that if the application was put in before the 1st of September, then it must be determined by reference to any use classes that were referred to in that application. I agree with Duncan that they must have been trying to be helpful. They were saying you don't have to change your application. Equally, I don't think it's restricting the applicant from agreeing an amendment to the application, if actually that would be a sensible thing, so as to give long-term flexibility when the permission is granted, but it would just need the assessment work to justify the additional flexibility that's opening up. And I'm saying that because a couple of the questions of the 23 that are scrolling through mention that.
I think there's a bit of a disjunct in a way between Article 4, which tells us that if prior to the commencement of the material period, so it's got to be pretty soon now, an application's been submitted, as Meeta said already, it's got to be determined with reference to the old use classes. All right, so it's determined. However, then Article 7 is that after, from the end of the 31st of August thereafter, the previous use classes will no longer have any effect at all. So you might get a determination that relies on A1, A2, A3 if your application's already in. But as soon as you've got your determination, looking ahead, the flexibility, subject to any conditions that might be imposed, the flexibility of Class E does kick in, which is, as I say, it's a bit of a disjunct if you have been, prepared your application solely on the basis of Class A1 or whatever it might be.
But you have to, the first use obviously has to be for what you've been permitted, and then you can change. Yeah.
Exactly.
Okay, again, sorry, conscious of time, so I just want to move on to, so that we hit one final issue perhaps before we then try and come to some individual questions. And that final issue is actually around operational development and the issue of external works. That was something that became a big issue with the change of use PD rights that we started seeing come in, particularly with the office to resi ones where there was considerable take up. Simon, can I turn to you on this point and how you think that might play out in this context as well?
Yeah, well, obviously the operation of the use classes order only relates to the uses to which buildings can be put, and doesn't in any way have any effect on the question of whether planning permission is needed for works which may affect the external appearance of a building, or which may need listed building consent in the case of listed buildings, because works which may affect the special historical or architectural character of the building, you will need those applications. You'll need those permissions, listed building consents, etc. As well, if works are needed in order to facilitate the change of use. And it is going to be, in some cases, a battleground, because authorities will see that as their only opportunity to, for example, try to control the amount of parking or the or other factors which go to the nature of the use. In my view, it should be looked at in a pretty pure way by authorities, which is the change of use is authorised, does not amount to development. Therefore, the local authority should not be by the back door be trying to restrict in any way that change of use in the way that it determines its application, the application for planning permission for external works, which is associated with that change of use. And if they go that way, then I think we'll see pretty suboptimal ad hoc changes of use without the external works to make it actually work properly.
Brilliant, thanks. I think that means that we've definitely hit most of the issues that we were planning to. There are some others that we will now cover through picking up some questions. So full disclosure, I am so good at tech, I'm actually struggling to see any of the questions that are coming through, but I'm assured that some of my panelists can see them. So I'm just generally going to turn to them and say, perhaps you'd like to answer a question, Heather. I think Steve Quartermain may have sent in a question, and also Lawrence Booker of Turley.
Yeah, dealing with the Turley question first, thanks for that. So the query was, if you've got permission for basically one of the existing use classes that are about to be consumed into Class E, and you've implemented the permission, but it's currently under construction, then will it automatically become Class E from September? The note of caution I would sound on this, and if it looks as though I've been scowling at the screen for the last 15 minutes, it's because I've actually been trying to find the relevant bit in the planning encyclopedia. But that says that basically to benefit from the use classes order, obviously the land has to be being used for one of the purposes that's specified in the relevant class. And the courts have insisted that the property must at some stage have actually been put to the use upon which the claim to the right to change the use is based. So a mere right to use it under an unimplemented planning permission isn't enough, and there's also case law to suggest that a token implementation of that right doesn't suffice either. It's a quick save case that's considered this previously. So I don't think actually, you know, if you're still in the middle of construction, that you would at that point benefit from Class E. I'd also say, as others have mentioned earlier, obviously watch out for the conditions that might be attached to the grant of planning permission to check that none of those are likely to trip you up either. And then turning to Steve's question, which actually I think is a helpful suggestion, rather than trying to restrict a permission to the permitted use, would it be possible to accept basically Class E changes, but then essentially condition against the ones that you don't want? I can't see any reason why not, to be honest, and that might be a neat way of achieving the desired result.
Brilliant, thanks Heather. Simon, turning to you, I think we've had a number of questions around F2. Perhaps you'd like to come back on some of those.
Yeah, so Parliament has carved out into a separate use class, F2, which is called local community, which is which is 4 different things, but the one I wanted to focus on was a shop mostly selling essential goods, including food, to visiting members of the public in circumstances where the shop's premises cover an area not more than 280 metres square, and there's no such facility within a 1,000-metre radius of the shop's location. And people are asking, well, how does this work? So does this mean that you have to have a small shop that is selling essential goods, including food, with no other small shops of that description within a kilometre, in order for that small shop to be in a different use class, so that it can't be changed to office or whatever? Well, yes, that is the case in my view, and it means that in urban areas it's just not going to be something which very commonly applies. And people have said, well, does this mean if I've got one, is it one butcher, like one baker, one? No, to my mind, it's selling essential goods, including food. And you look round to see if there's another shop selling essential goods, including food, within a kilometre. That's my reading, but I think there's going to be a lot of interest in that provision.
Thanks, Simon. Zack, a couple of questions for you. Herbert and Linda Boateng's question.
Yeah, Linda's question we may have actually managed to deal with. So Linda asked how the mix of uses can be controlled after the 1st of September when you've got an extant application where a resolution to grant comes before the 1st of September and conditions have been approved by members, but where the permission is issued after the 1st of September. And as we've touched on, a couple of us have touched on already, that the key bit of the amendment order to think about is Article 4, which tells us that if prior to the commencement of the material period an application was submitted, and then you have to determine it in relation to the old use classes. So that's the answer there. The key date for these purposes is the date of submission. However, TBD, as I've said already, the consequences if you get an approval for under the old use classes, how you can go about seeking to change your uses thereafter, given the flexibility afforded by the new Class E, a discussion we've already had. And Catriona Herbert asks a really fun question, which is this perhaps the first step towards a US town planning methodology of zoning in different areas as flagged in the media? Where to start on that one? But it struck me perhaps counterintuitively that actually if you were going to design a system of zoning that looked anything like the Euclidean systems of zoning that you get across lots of cities in the States, notably New York, this would be the very last thing that you'd want to do, would be to compile all of the uses that we currently have neatly distinguished into a big old umbrella use of Class E, because those sorts of Euclidean approaches to zoning rely on these sort of micro distinctions between uses to put together their mega zoning codes, which can stretch to thousands of pages, to tell you exactly where everything needs to go. So it's sort of antithetical to that kind of zoning. However, we all have seen the news stories over the weekend, when we are promised later this week. So, you know, fingers crossed, there'll be some news before the weekend on the consultation paper to introduce 3 zones of development: a growth zone, a protect zone, and one in the middle where you permission in principle zone. And clearly it may well assist, I suppose, in the growth zone to have fewer divisions to enable the facilitate growth, build. But we'll have to see, and we await the detail in a few days' time, Catriona. So we'll wait and see.
Thanks, Zach. Yep, definitely looking forward to where I live looking like Bath, Belgravia or Bourneville. Duncan, there's a question about the lifetime of the regs. Perhaps you could deal with that one.
Yes, I think someone raised the question, given the ramifications we're all talking about, whether there's a precedent for regulations being withdrawn before they come into force. And it is a good question. I don't think there is a precedent for that. And I think in this case, the government genuinely think they're doing the right thing. Otherwise, you know, why would they not? Why would they be proceeding without consultation? But I think playing it forward a little, there's reason to think, in my view, that these regulations will have a short lifetime in their current form, and we may well find in 12 to 18 months' time they become limited. And I say that for 2 reasons. One, voter and councillor pressure, because I think, you know, if the full ramifications of this, particularly Class E, come to play, then, you know, the reaction of, you know, local people and their representatives is going to be significantly adverse, and that will be made known to government in no unclear terms. Secondly, because I think there's a potential for this to disrupt the delivery of housing through PD. If you have a wider choice of uses, commercial uses in Class E, you know, some landowners will look to those uses before considering changes to dwellings. And I think if that does happen, and there is a slowdown in delivery of homes through permitted development rights, again, that may be another reason for the government to limit the effect of the current amendment as it stands.
Thanks, Duncan. I think we've got time for one more quick one, and I think Heather, the issue of reserved matters is causing a lot of confusion. I think perhaps you can hit that one as our final issue just before we wrap up.
Yeah, thanks, Meeta. So one example in the questions was, if a site has outline permission for a B1 use, then following the changes, would it technically be possible to submit a reserved matters application for another use within the new Class E, such as retail? Others may differ, please shout at me if you do, but my view is no. I think it's quite clear on the existing case law that you can't fundamentally change, you know, your scheme through reserved matters, and clearly a change from, say, office to retail would, I think, be a fundamental change that you can't push through at reserved matters stage. So that's my view on that one.
Okay. Does anybody want to come back on that? Or yeah, we're all in agreement, I think, Heather. I think just taking one look at the time, we have probably come to the end of the session. So just very, very quickly, thank you all of you for tuning in, and thank you to my lovely panel, Simon, Heather, Zack, Duncan. If you feel as though you can actually take some more, please do join us for part 2 on Thursday at 5 PM, another shameless plug, when Zack and I will be turning up again and discussing the planning implications rather than focusing necessarily strictly on the legal ones. With another stellar panel, we've got Steve Quartermain, Mike Meadows of British Land, Alice Lester, Operational Director of Regen at Brent, Sarah Carey, Executive Director of Place at Enfield, and Victoria Hills, Chief Executive of the RTPI, and of course Zack, possibly with slightly more beard. On that note, I think it's very, very definitely wine o'clock, and hopefully see some more of you on Thursday. Thank you for joining.
Thank you, Meeta. Thanks, everyone. Goodbye.
Bye.